Yeah, I was going to do that, and then I know you.
Related party questionnaire for the auditors. They're getting started on our audit for last fiscal year.
It's a Thursday, Friday, and Saturday.
Even that do one, and before, what's that one time? There's they used to have us do all the partner heads, they'd fill one out.
So we won't be there for some. That way we can get that coverage up on that in the afternoon and have the one at the library for the so. I'm gonna be here before we know. Yeah, it will.
Yeah, I was gonna ask you that.
For about a week after we got this letter and worked on this, email back a little.
No.
I really think.
Tonight, hold it, give them all that.
I don't know, I think I'm gonna charge Greg.
And our association, our trade raises rules, the former secretary. Deals with the treasury, who's going to issue with revenue, with COT, KYTC, and all these people involved in it, which would have been even harder to figure out. No, we got that's possible
Solution.
Yes. Yeah. I just don't know why revenue didn't think about this like last year. So we and adjust it.
You know, the COVID, you don't know what you're going to everything.
You don't know, but I mean, I think they could have done a little bit of projections, economic projections to see the housing, everything else. And they're not 40% because of the market, you know. Yeah.
Father, Heavenly, thank you for another day. Thank you for all the blessings you give us each and every day. We ask you for the wisdom and guidance tonight as we make these decisions for the county. And we pray that what decisions we make will be the best. Thank you for your Son, Jesus Christ, who went out on the cross to forgive us of our sins. We and may have everlasting life. It's in his name we pray. Amen.
Join us in the pledges, please. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And our Kentucky flag. Pledge allegiance to the Kentucky flag, the sovereign state for which it stands, one commonwealth, plus diversity, natural wealth, beauty, and grace from on high. Thank you very much. Meeting order, the clerk will call the roll, please.
Squire Brewer.
Here.
Squire Mike Moody.
Here.
Squire Heberson.
Here.
Coach Riley.
Here.
Squire Travis.
Here.
Squire Jerry Moody.
Here.
We are ready to conduct business, and the first will be the approval of the minutes of February 7th meeting. Entertain a motion.
Make a motion that we approve the minutes with any corrections necessary.
A good motion,
Second?
and we've got a second. Any corrections? Hearing none, call the roll.
Squire Mike Moody.
Yes.
Squire Heberson.
Yes.
Coach Riley.
Yes.
Squire Travis.
Yes.
Squire Jerry Moody.
Yes.
Squire Brewer.
Yes.
All right. Next item of business, communications from Judge Executive. I have none. Communications from citizens. Do you have any citizens that would like to address the court this evening? I don't see a foot race. And we're going to move on then to communication reports from members, other offices, and committees. First up, and I don't know that Julie is here yet, so we're going to move on to the time being. Hang on just a second. Oh, I think I heard her. Okay, for the time being, we're going to move on to EMS, emergency management. Chris, anything?
Nothing to report.
All right. The safety committee?
Yes, on February the 10th, we had an employee, James Martin, had an incident. He was working at the Waterford Park cleaning up tree limbs. When they put the tree limb into the chipper, one of the tree limbs jumped back and hit him in the ear. He started bleeding from the ear, took him to EMS, and they examined him, found out there was nothing stuck in his ear, recommended they go to the hospital. Went to the hospital, they said that he had a ruptured eardrum, and I believe they did drug testing, is that correct?
Correct.
Okay. So he come back and filled out a workers' comp report, I do believe. The only thing other than that, with that being said, is we need to ensure that our employees are wearing the proper protective gear. I mean, had he been wearing earplugs, or ear protection, muffs, or even earplugs, I do believe that this could have been very well been prevented.
I believe you're right. Anything else with the safety committee?
Nothing. Thank you.
And then solid waste.
Nothing to report.
Nothing to report. Veterans committee report.
Nothing to report.
All right. Equipment committee reports.
International truck, 6,000 to my college.
Close to the top end of what they said would be the worst case.
14,500.
Yeah. But that was just, the 6,000 was just the steering, right?
Yes.
And I think they estimated that at, yeah, it was the top end, but.
And then the Ford truck, they got the part this time.
Yeah, what?
The new Ford truck, they finally got the part.
Oh, okay, all right.
We had a new one down.
Okay.
A few weeks, but the part.
Is this a road department?
Yeah. Okay, anything else? You're not gonna report that we got the coroners in? We'll have something come up on it
Yeah,
here in just a
we
minute.
got a bid coming up on that, and we did.
Right, okay.
Did you turn it, Brett, did you turn it on?
I did.
Thank you.
Thanks for reminding me.
All right. Telecommunications.
You got your battery. Nothing.
Oh, yeah, Ken's battery is dead, but we'll be able to, you're gonna be up next, so, or just shortly, I'll say. Telecommunications today, nothing to report.
Ken Jones has a microphone that doesn't work.
Ken Jones has a microphone that does not
That's all I
work this
have.
evening, so he will be speaking loudly. The only other thing, I just want to finish this up before we get Julie, is that there's a letter in your packet about this. We did receive a donation for dead animal pickup, and it was very welcome and appreciated. So with that, I'm going to move back up to number 1, the zoning readings and recommendations.
All right, we have some second readings here tonight. So the first one I have is that of George W. McMichael Jr. requesting Ag 1 agricultural to R1 single-family residential on 1.921 acres located in the 4200 block of Plum Creek Road. Commissioner Wheatley made a motion to recommend the rezoning of George W. McMichael Jr. The application requesting zone change from Ag 1 agricultural to R1 residential on 1.921 acre tract of land located in the 4200 block of Plum Creek Road. The recommended land use map in the comprehensive plan recommends low-density residential, and the change would be in compliance with the comprehensive plan. There was no one there to speak against it. That motion was seconded by Commissioner Mudd. Motion carried. This is in District 2.
Motion to approve planning and zoning requirement or request based on facts and findings of planning and zoning.
Recommendation.
Yeah, recommendation.
Okay. Second motion, and we got a second. There's no comment. All those in favor say aye.
Aye.
Anyone opposed? Hearing none, motion passes.
Next, we have the application of Chris and Kylie Grossman requesting Ag 1 agricultural to Ag 2 agricultural on 5.30 acres known as Tract A in the 1100 block of Murray Road. Commissioner Wheatley made the motion to recommend to rezone the application of Chris and Kylie Grossman requesting zone change from Ag 1 agricultural to Ag 2 agricultural on 5.30 acres known as Tract A located in the 1100 block of Murray Road. The recommended land use map is low density to medium density residential. The change would be in compliance with the comprehensive plan. They did add a binding element allowing an easement for access to Tract A through Tract B. That was seconded by Commissioner Mudd. Motion carried. This is in District 4.
That would be Jerry.
Motion to approve recommendation of planning and zoning based on facts and findings of the planning and zoning board.
Got a motion,
Second.
and we've got a second. All those in favor say aye.
Aye.
Anyone opposed? Hearing none, motion passes. Number 3.
We have the application of WCM Land LLC Series 16 requesting Ag 1 agricultural to R1 single-family residential on 97.243 acres in the 1900 block of Plum Ridge Road. Commissioner Mudd made the motion to recommend the rezoning of the application of WCM Land LLC Series 16 requesting zone change from Ag 1 agricultural to R1 single-family residential on 97.243 acres located in the 1900 block of Plum Ridge Road. The recommended land use map in the comprehensive plan recommends low to medium density residential. The change would be in compliance with the comprehensive plan. There was no one present to speak against it. That was seconded by Commissioner Fowl. Motion carried. This is in District 2.
Motion to approve recommendation of planning and zoning based on the facts and findings of planning and zoning committee.
Got a motion
Second.
and a second. All those in favor say aye.
Aye.
Anyone opposed? Hearing none, motion passes.
Next, I have the application of Clear Dreams, Inc., requesting Ag 1 agricultural to R1 single-family residential on 65.44 acres. Also, Ag 1 agricultural to Ag 2 agricultural on 0.64 acres located on Post Roster Road. Commissioner Fowl made the recommendation for the zone change for Clear Dreams, Inc., requesting Ag 1 agricultural to R1 residential on 65.44 acres. Also, Ag 1 agricultural to Ag 2 agricultural on 0.64 acres located on Hostrasser Road. The 0.64 acres is lot 49 on the preliminary plat. The recommended land use map is medium density residential. The change is in compliance with the comprehensive plan. The zoning change is tied to a preliminary plat approval. No one was present to speak against it. That motion was seconded by Commissioner Wheatley. Motion carried. This is in District 3.
I'll make a motion that we move this second reading to our March 21st meeting, so we'll have time for further review.
I will second that.
Okay, March 21st, you said?
Yeah, I think that's our,
Will that need to be re-advertised or?
The way I understand it, as long as you continue to date specific, you do not have to.
Okay. Okay. We've got a motion in a second. I'm not sure what will accomplish with a delay like that. And I want to caution everybody on the court about communications on this matter. The public hearing was held over in planning and zoning. I just want to caution members of the court, if we're going to delay this, to use very extreme caution on discussing this. Got a motion and a second. Any comments, questions, or concerns? Call the roll, please.
Squire Jerry Moody,
Yes.
Squire Brewer,
Yes.
Squire McNamee,
Yes.
Squire Feverson,
Yes.
Judge Riley,
No.
Squire Travis,
Yes.
Motion passes. It'll come back up on March the 21st.
And I do have one other thing that relates to this.
Oh, okay.
Are you going over back to school, 51, you can stay on foot?
I would also like to make a motion that we hold our own public hearing here in fiscal court on this issue. And that is the motion.
Motion for fiscal court to hold our own public hearing.
I will second it for discussion.
All right.
Well,
Just so we're clear, you're talking about planning and zoning.
same type, yes.
Right. Julie, you want to tell us how that's usually accomplished?
I mean, the main thing with it is you have to follow your comprehensive plan, and you've got to create findings of facts that follow. And your comprehensive plan is like the roadmap to what you think should happen in your county, and it's done every 5 years. So the planning commission addressed that. So that's something to think about, that is, you would need to research to see if you don't feel it needs that. To do a public hearing, we have to notify all neighbors again. It's only adjoining property owners that receives new notice. That has to be done 14 days in advance prior to the hearing date. You've got a no less than 7, no more than 21 public notice. time, we would swear people in to get up to give public testimony to speak. I mean, you'd just basically be sweeping the planning and zoning hearing that happened under the rug like they didn't do anything, and you're starting fresh, doing your own.
Well, I'm sure there's maybe some discussion around the table.
And who would head that hearing up? Who would be in charge of that hearing?
Not sure.
I think it would be
I don't think it's me.
No,
You would be the one that set it up, though, wouldn't you?
No. I don't think so.
Why not?
Because you just skipped over my process and you're taking it on for your own. I mean, we have to find out about it, but I mean, most communities, their zoning administrator doesn't even present the files to the fiscal court. They just send you all paper records and they don't even go. So that's a rarity too, that, you know, I come and present them to you. So by doing, like I said, by doing your public hearing, you're basically saying what planning and zoning did. What we did was no good, and you want to start all over. It's
Well-
kind of what we're doing.
Well,
If you start,
yeah.
you know, if you start fresh, because you're gonna have to create your own findings of fact, you're not gonna use ours anymore. You're doing it all on your own.
Yeah, well, I'm not saying that the planning and zoning was no good. I'm just saying that there was issues maybe wasn't looked at as closely as what we could look at, and that's what I would like to do.
I mean, I think that, you know, Ken might have to, check with the higher up authorities, you know, higher than me, as to how it happens. You know, I don't know that fiscal court's ever held a zoning hearing in 25 years
Right.
that I'm aware of, so it'd be a whole new ballgame.
We cannot discuss any of this in this meeting. We know that as far as facts and findings or anything. We need to make a motion to do it, and if we do it, we do, if we don't, we don't. So, but we cannot discuss anything, from what I understand.
I mean, like I said, you would have to talk to the powers that be in Frankfurt probably on what your next steps are. I personally, I don't know. I know statute for zoning hearings, you have to notify just adjoining property owners, and that's whoever touches your property. You have to post a sign on the property, and then you have to run it in the paper. Like I said, no less than 7, no more than 21 is the days on that.
Was this notice put on the property owners at this first rezoning meeting?
Yes. There, we are required to do signs. The signs are about the size of that white erase board over there. And I think I gave them 2.
You did.
Usually, you know, because there's 2 different zonings, they should have had 2 different signs to be posted there on that property. And that too has to be posted the 14 days before the meeting.
Who actually posts those on the property?
The property owners post them.
The property owner of the development?
Right, whoever has made application is who posts them. You know, a lot of times we give them zip ties and, you know, and they can put them on a fence, they can, you know, put tobacco sticks out there and put them up, however, but they have to be posted prior to the meeting.
How do you ensure that that is done?
A lot of times we check to make sure those were, you know, that they are posted.
Did you
I
check
mean, I
to
don't-
make sure that this was done?
I mean, in general, nobody's not gonna do it because they know it's gonna mess up their meeting.
I just will say, if this is in my district, if there is some serious safety issues with this development, and that's why I'm asking for this delay, for a 30-day delay, which will give us time to get the meeting over, this public meeting, and get it set up and going. So it's a very serious situation, and I need support from you guys to we can hold this meeting, and we can bring about our own facts and findings, and if it's legit, then fine. If it's not, then it will pass it. So that's all
Judge,
I'm asking.
if I may, how many times have we sat around this table and said that we're fixing problems based off of decisions, 4 decisions that was made 20, 25 years ago? Those same words are going to be echoed 10 to 15 years from now about this court if we don't at least consider what Squire Travis has put the proposal before us. The land that the planning and zoning is talking about will be developed. There's no doubt about that. 5 to 10 years from now, the 200 to 300 acres across the street will also be developed. There's probably no question about that. That's going to leave you with an average of an additional households of about 150 to 200 houses. Okay? How many cars is that going to put on these additional roads? It is our responsibility as fiscal court, along with planning and zoning, to ensure that the community and the county has the best possible roadway systems that can be afforded. It's time that we start planning for the future. Okay? Be proactive and not reactive. That's all I'm going to say. Thank you.
I believe some of that's been addressed already with our zoning, our subdivision regs and requiring improvements to roadways. I know exactly what you're talking about because there's one right there on Washburn Lane that I spoke against. When it came up, I think in 2001 or 2, maybe 3. And I was asking for improvements to be made to Washburn Lane and planning and zoning. Well, we didn't have the regs in place. Now you would have to make those improvements. So, you know, I don't think you can look back at some of the problems that this court, maybe the previous court, had to correct. A lot of that has been corrected. I'm just very much opposed. I'm opposed to delaying the decision on this particular application until March the 21st. That's why I voted no. I am opposed to basically ignoring what planning and zoning has done. That's the function of planning and zoning. I don't believe that the members of this court are equipped with the knowledge and experience of some of the planning and zoning issues that must be considered in order to hold a public hearing. But I just don't think that that's our place to do that. It hasn't been done, to your knowledge, at least in 25 years. I don't think now is the time to start doing that. I think the planning and zoning does a good job. They are restricted with some of the regs that we put in place. So I encourage the court to not go down this road of us then taking the role of planning and zoning.
I am not in favor of doing a hearing. I am not in favor of that.
Okay.
But if that's the only way that we can get something said and done to where this is looked at a better, because it's going to pass. And we're not talking about subdivision road. We're talking about a main road that's on the outside of the subdivision. We're not just talking about the inner portions of the subdivision.
I think it's the taxpayer's responsibility. When a developer comes in, he's gonna make darn good money. And I don't think it's right for my area farmers to have to pay extra taxes or something to build a road on the other side of the county. It's not our responsibility. Period, paragraph. And another thing that is completely wrong, like on this one that we're getting ready to discuss in just a few minutes, is this builder or developer has agreed to do extra, but then they wanted to build a road around there. But the thing is, and I don't disagree with any of it, but the thing of it is, as soon as he gets that built and everything, then another builder will come, developer will come on and build another piece of ground, and he's done widen the road, made a curve out there, and this other one's gonna make a whole lot more profit because he doesn't have to do anything on that road. And that is not right. I mean, it should be, if it's one developer, and I don't even know the gentleman's name, but if he's got to spend all this money to do it, then another, and he gets it done, then another builder comes in and don't have to do nothing because he's done with it. Now, is there any way that something can be set up for the first developer gets reimbursed for part of the cost? I mean, we've got to be fair, and if we don't stop developing, this is going to be this is going to turn into this whole development thing. We are not ready for it. We use QK4 And sometimes y'all will not agree with what the engineers tell you. You fight them. Now, we have not got the brains to do this. Anybody that's got any smarts at all, no, we are not engineers. And we're setting the county up for a big mess. It's all.
I will say that every one of our districts are subject to go through exactly what Elk Creek is fixing to go through. So you can't say that, you know, your constituent's gonna have to pay for this or whatever. Any one of our, or any one of our districts can go through the same
If we're
exact
gonna
thing.
spend the money over there, then I want the same amount of money spent on my road.
Well, we're hoping that this can be worked out with the developers.
Jerry, this is not gonna cost the county a penny, what I'm advocating. No,
No,
this is on the developer, not on taxpayers.
But we're not being fair to that developer.
Well, our regulations are in place, and if you read them, it says that any property that adjoins a county road that is not up to standards, that developer will have to widen that road to 20 feet blacktop. Now, it would be up to the developer and his neighbor to come to an agreement, not us. That's a private deal. It wouldn't be to us to tell the neighbor, you're gonna have to split half of it with him. He just happens to be the first one to do this, so he's gotta be the one to widen the road. If his neighbor wants to chip in and help him out, that's fine, but that's a private deal. It doesn't have anything to do with the county.
So the guy, and then the guy's not gonna do it. I mean, I wouldn't, if I was a developer, I wouldn't develop a road and then let somebody suck in on the other side after I do it, don't cost them nothing.
I understand what you're saying, Square Moody, and I think that there are provisions that it seems like I'm aware of with extending sewer lines, where a developer might extend a sewer line, but then another developer takes off, and there's some provision for, it's worth doing some research to understand. And Eric, I don't know if you are familiar with some of those arrangements on sewer lines or even roadways.
Yeah, we are, and there's a number of different ways of doing that. What a lot of communities are doing right now is a public-private partnership. So the first developer will build the sewer line, but then owns it for 20 years. So then fees from that sewer line go back to the initial developer.
Yeah,
So
it'd be difficult to do with a roadway because it'd be different.
Roadways are totally different.
Totally different, yeah.
That's right.
You know, I agree with the concern, and certainly the developer would be, but I guess it behooves her not be the first developer on the block, but, in terms of roadways. But, anyway, our motion is to, correct me if I'm wrong, to have fiscal court conduct a public meeting on this rezoning issue.
That is correct. That is the motion. And it deals with not the rezoning, you know, the rezoning is no problem, you know, from ag to residential, no problem. It's a safety issue, roads, and safety issue down the road, 20 years down the road, with all the development that's going to come in behind this development. There's 600 acres behind this one coming in. It's all going to be coming in the next few years. And if we have the opportunity to solve a serious safety issue, and by having the developer do a different section of road from what's there now, and it would solve the problem. And it would make the roadways for Spencer County much better in that area for the years to come. That is the issue, not the rezoning.
I mean, I don't know if I'm allowed to ask or interject anything here, but my thoughts are, even when you say a public hearing, that, like I said, that means you're notifying neighbors, adjoining property owners to come in and they can testify. And like I said, you put them under oath and, you know, you're holding an actual hearing.
Yes.
I don't know if that's something you really are wanting to do. I don't know if I'm here, or if you're just wanting to be more where you all can sit and talk and hash out your ideas.
No, I want the public to come and be sworn in, because I have numerous people in my district that have called me and want to come and discuss this, and that's the only way we can discuss it, is at a public hearing where they can get up and tell their side of the story.
Okay.
And I think the
Just wanna
citizens out there deserve that. If not, this thing is just gonna be stuck down our throat, and we'll be right back where we started.
I mean, I was just, like I said, just clarifying, because we did our notices, they were welcome to come and speak and be sworn in and say their piece at the planning commission meeting. Some of them did do that, I'm sure there's other people that just didn't come, but, we gave them that opportunity, it's not something that we kept them from doing. They had that opportunity with the planning commission.
Like I say, this is not costing the county anything to hold this meeting. It's only be, let the people out there know that we are looking at the situation and not just taking phone calls and saying, I'll look into it. We're being transparent as much as we can. And I think this is the proper way to go, and it's the legal way to go.
As Squire Travis noted, the issue is not the rezoning, evidently, at least if I heard right.
You heard me correctly.
The issue that I think Squire Travis has is some safety issues. What is required of the developer? My understanding, the developer would only be required to make road improvements on property that abuts their development. Is that correct?
Right, that's what's in the ordinance that we just passed. It states wherever they are developing, what adjoins the county road is what they have to widen.
Okay.
So the whole length of their property that adjoins the road is what they're required to widen.
So anything that...
And I have no issue with that, the widening of that road, perfectly well. He's agreed to do it, it's in our regulations. That's not what I'm talking about. It's the safety issue of the intersection of Washburn Lane and Holy Cross.
And I did put, packets to email from our engineer to Squire Travis, who asked them to look at that. And I believe that the safety issues have been addressed, so.
Judge, I don't think we should be talking anymore about this. We have a motion.
The motion is to hold a public hearing in fiscal court. Any other discussion?
Yes, I'll just say, if we do not do this, then this development will be okay, not tonight, but March 21st, we have no alternative but to approve it.
Well, certainly we can add binding elements if we feel like it was something that...
Don't think so. Don't think legally we can do that.
Correct me if I'm wrong, Julie, fiscal court, when it comes to us, we can...
I mean, I feel like you can, but like I said, we can check with powers be, a little higher up and make sure.
I believe that
We've added binding elements before.
yeah.
I have,
And of course, the developer would have to be agreeable to those binding elements. But
well, if the developer is agreeable, if not agreeable to them, why put them on there? That's the thing I'm saying, We can put all the binding elements on any development we want to, but if the developer says that they don't want to do it, then we don't have a legal standing to make them do it. That's my point.
By definition, all binding element is something that the developer does for example. So if he doesn't do it,
I can't hear a word you're saying, Tim.
it's not a binding element unless the developer agrees.
Right, that's right. We can't just unilaterally put an element on there. Yeah. Okay. Which we can do, and I think you've addressed that, but having the engineers look at the issue that you've raised, and
Those issues would come out in this public meeting where we can talk about them.
yeah, well,
And they need to come out.
okay. Everybody ready to vote on this motion? Call the roll.
Squire Brewer,
No.
Squire Mike Moody,
No.
Squire Beaverson,
No.
Judge Rary,
No.
Squire Travis,
Yes.
Squire Jerry Moody,
No.
Motion failed. So, motion did pass to delay action on this to our March 21st meeting, and so that's what we will do. All right. Next item of business would
Judge,
be...
can I
Yes, go
say
ahead.
something under communications from other officers?
I'm sorry, yes, go ahead.
Thank you. There's been a lot of talk about the valuation on the 2022 vehicles being raised 40%, and last Wednesday, I believe it was, the governor ordered an executive order that is going to roll the valuations back to the 2021 values for 2022 and 2023. The way that's going to be done for the people who have already paid their taxes is the Treasury is going to send the refund checks out. They're not going to be sent out by the county clerk's office, even though the executive order says that. There will be an amendment to that executive order. They'll come from the Treasury. Those refund checks must be sent no later than 180 days from February 16th. Because of the governor's executive order starting February 16th through February 26th, PVAs may adjust vehicle values to the corrected 2021 values. The clerks will keep on processing, renewing the vehicle registrations as normal. Vehicle values will be updated in our vehicle registration system back to 2021 values on Sunday, February 27th. While the March notices have already been sent to vehicle owners starting February 28th, when the payment is processed, the payments will come up and the true values will come up in our registration system. April notices will be sent with the corrected 2021 value for each vehicle. And the refund procedures for local taxing districts are still being developed, but I believe they're going to come from the Revenue Department, and they will take some money off of forthcoming payments from the state to the taxing districts. Just wanted to make everybody aware of that.
Thank you.
All right. Anyone else for communication report from members, other offices, and committees? All right, moving along, old business Ray Jewel Lighting Phase 2, Mike Moody and Tim Brooks.
After reviewing the bids, Squire Moody and I have come to the conclusion that J. George Solutions would be the one that we would recommend. Currently, that bid is $120,650, $121,650. Yeah, thank you.
I see what I said, $126.50.
We currently have $50,000 in budgeted for that. We would have to come up with an additional $21,150 for a total of $71,150. I make the motion that we approve that.
Okay, we've got a motion and a second. We've got a grant that's been approved for $49,500. So the balance would need to come from fiscal court or possibly the baseball association, which I don't think.
After speaking with the Baseball Association several months ago, they are not in position to be able to do that
Brian
this
Bear's
time.
Foundation, have you talked to them?
Yes.
Okay, then they're not either. So your recommendation is to go ahead and award this contract to J. George Solutions.
That is correct.
And to come up with the balance in order to be able to pay the bill, right?
$71,150.
All right, you've got a motion.
50,000 of that was already budgeted, has already been budgeted.
Also, second.
We got some things already.
Oh, you missed that.
Oh, yeah.
We've got a motion and a second. Any other discussion?
We have
comments?
50,000 budgeted. We have a grant for almost 50,000. So really, we're looking at putting another 21,000
No.
into this.
$21,150.
Huh?
Additional.
Over what's
Over
Oh, what's budgeted plus the grant, okay.
The grant still
I
have,
think
we
the
still
grant
have to
was what we
transfer,
essentially
we
budgeted.
still have to transfer $71,000
Yes.
that line item.
Right. Okay.
Or amend the budget that way with the grant. And right now,
I will, work with the treasurer and the finance officer and see what we'll need to do to make that transfer. But in the meantime, you want to go ahead and award the contract to J. George Solutions. And, you could just clarify that's your motion.
That is my motion.
Okay, and that is seconded by Mike Moody.
Yeah, this is the kind of information that's helpful ahead of time. On the cover page where it says budget considerations, it's blank. So now here, as the motion is being made, we're getting lots of details.
Well, not really. I mean, we know what the contract is, $2650. We've got any grant money to cover $49,500 of that, so we would need to cover the contract. So, all right. Any other questions, comments, or concerns? If not, call the roll.
Squire Mike Moody,
Yes.
Squire Beaverson,
Yes.
Judge Riley,
Yes.
Squire Travis,
Yes.
Squire Jerry Moody,
Yes.
Squire Brewer.
Yes.
All right. We'll get that award letter out to them, and we'll get that working. By the way, the Baseball Association, as you guys probably know, have been notified that we're going to be holding the 8U statewide tournament. So hopefully we can get this in place and done for that tournament. So it's pretty awesome to get that tournament here. So next up, new business, ARPA resolution number 1. Let's see. Whereas Spencer County Fiscal Court was allotted $3,758,705, and whereas the county, as of this date, this resolution has drawn down the first of 2 tranches, is $1,879,352 in the fiscal year 2021, fiscal year ending 2021, and to draw down the second and final tranche in the upcoming fiscal year 2023. We could, depending on what the court would want us to do, we can go ahead and draw that second tranche down now if you want, but I'll leave that up to you all. I figured, we've drawn the first $1,000,000, almost $9, and spent a scant little of it, so thought probably best just to wait until next fiscal year.
Can we draw interest on that if we do?
Possibly, yeah. Anyway, whereas Treasury has recently issued a final ruling with the details and guidance on the options of proper use of the funding. Now therefore be it resolved, Spencer County Fiscal Court hereby elects to make a one-time election of the standard allowance for revenue loss such that the amount of the reduction in the county's general revenue due to the public health emergency over the period of performance will be deemed to be up to $10 million. This is what U.S. Treasury ruled. We obviously don't have a $10 million, but this is basically declaring that all of our $3.758 million would be as lost revenue and allows us to use that money as general fund dollars with some guidelines from the federal, because it's federal dollars, so we have to abide by their procurement laws, but we need to adopt this resolution in order to actually make that claim. So I'll entertain a motion.
Motion to approve.
We've got a motion.
I will second.
And we've got a second. Any questions, comments, or concerns?
I do have a question.
All right.
This basically says that we lost almost $3.8 million in revenue.
Well, it's a standard claim of up to $10 million, so that's what we can take that standard.
We didn't
We didn't have any revenue losses.
Most, I'd say probably most if not all counties in Kentucky or across the nation can claim that. That's why it was so important that Treasury
I agree with it.
take some of the strings off of us.
Yeah, it simplifies a lot of things for the
Yeah.
treasury. However, if you vote for this, aren't you voting that we lost
No,
$7 million?
no, we're just claiming,
What it says, well, it says we're claiming it for lost revenue.
we're claiming the 10 million standard option, which means that we can use that money as if it were lost revenue. We're not saying that it's lost revenue. We're taking the standard claim against the 3.758 million.
But it doesn't say as if it was lost revenue. It just says it's lost revenue. The way I read it.
This is based on the Treasury's ruling in the final rule. They're saying that you can take a standard claim of up to 10 million. And in this case, it covers our entire allotment.
You understand
We
it
can
covers-
claim that,
I understand that.
deduct, or not a deduction, but that option. And then that allows us to use it as similar to lost revenue, which didn't have as many strings attached as some of the other provisions that we could use this for. So in order for us to use that 3.758 million, we're going to be required to adopt this resolution, basically taking that option.
And how does that leave us with the money we paid Clifton? We still have to give them a cut on the other part?
Yeah, nothing's changed there. It's just
So
it
we're just
allows
giving
us to
them
use.
About $40,000 for nothing now.
No, that's not true. No, they're still advising us, and they're still.
We're going to do about 1% of the work they were going to do for it.
No, I disagree. There's still a significant amount of reporting and making sure this is one of them. I think the next, they are still advising us, and believe me, they're going to be earning money. So,
There are still certain things that we can't spend this on, right? And Kip does advise us what those options are.
right, and that's why they're advising us, and I'm a believer in it, when we spend this money to do it, resolution. One of the things that I guess we did do a resolution, but not a formal resolution like this, but that was on pledging the 500,000 for broadband expansion. That hasn't come forth yet, but when it does, we committed 500,000 of the 3.7 million for broadband expansion. One thing that we just talked about is the lighting on the baseball field. Before, and I don't know if this will change because of this ruling from U.S. Treasury, is we could not use federal funds to provide a match to a federal grant. So we got $49,500 grant for lighting. Can we use $71,000, whatever it was, to provide the match for that lighting through because of this? I don't know. Kip is going to have to advise us on that. Kip is going to be there for a good reason. That's because I have trouble on this ARPA. So anyway, we've got a motion, we've got a second to adopt this resolution. Any other discussion? Call the roll, please.
Squire Peterson,
No.
Judge Wright,
Yes.
Squire Travis.
Yes.
Squire Jerry Moody,
No.
Squire Brewer,
Yes.
Squire Mike Moody,
No,
Okay, the motion fails for tie vote. It's a huge mistake, fellas. And we'll try to figure out how to get out of this hole. So next up is ARPA Fund Resolution number 2. I'm going to ask that we skip over that based on what happened earlier in the meeting. And we're gonna move on then to ARPA funds request from the fire district. Fire district has made a request for ARPA funds. And, we've got Chief Mason here to answer any questions you might have. Chief, would you like to speak on this topic?
Yeah, just briefly, and like you said, I'll answer any questions you have. This is the same thing we submitted to you, I guess, back in June. And I know you all cautiously at that time were waiting on rulings and so forth. And like the judge was talking about, basically up to $10 million, you all pretty much have a lot of discretion of what to do with those funds. So initially our request under the guidance didn't fall with under it, and now I believe it does, from talking to KIPTA and so forth. And one thing I want you all to know is when we made that back in June, I believe it was, and then coming back with the same thing today, we truly looked at needs and not wants, and things that would enhance the fire department that we currently do not have in our budget. And we made an effort to keep our requests low because we know you all have a lot of other things that, you know, whether it's things you all do directly or things you support, you know, need attention to. So we kept that request at $75,000, which equaled 2% of that total 3.7 or whatever. And I'll just say some of the things we outlined. I'll just go over real quick. 5-inch hose there, that's supply hose that would go on 2 engines. We just recently, well I say recently, it was over a year ago, ordered a new engine, which is going to be going to Elk Creek. It should be in the next month or so. Half of that hose would go on that engine and another would replace on an older engine. 10 sets of protective firefighting gear, $27,000. Obviously, when things get wore out or tore out, you have to replace them if it's not feasible to repair. But there's also standards today that, regardless of the shape, that stuff's good for 10 years. You have to toss them. So we have some that are entering that. The other item was a battery-powered extrication tool. Just like a lot of things, a lot of the tools and equipment that used to be gas-powered, we are going to battery-powered equipment. Chainsaws, the jaws of life, you commonly hear it referred to. That was for one of those. And one thing that is really, obviously we've had the lake for a long time, but the last, I would say 5 years, has really took off is kayaking and emergencies that we make on the Salt River and other waterways. The activity's really increased in that. So, you know, we've kind of redirected some of our training and purchased a different boat better for that, and some jet skis to respond to some of those emergencies. But we're kind of looking at getting some additional personal protective equipment, good for cold water and things like that to better respond to those emergencies. So, you know, we just respectfully ask that you consider this. It would definitely go to benefit the citizens of our community. And while I respect everybody's different opinions about these funds, and I know we all have different political views and things on the state, local, and national level, if we don't spend this, or if you all don't spend this money wisely, the only people it is going to hurt is the residents of our county. So while I may sit up there and I may not be for this, I mean, you know, somebody else made those decisions. And I would just respectfully ask that whether it's this request or any other request, if we don't give those serious considerations, we're just hurting our own people. So, any questions, I'll be happy
Chief,
to try to
I couldn't agree with you more, and what I'm going to ask is that we delay action on this based on what we did not do on the resolution adopting the new guidance and ruling from the U.S. Treasury. I'm not sure what we'll, you know, we're saying, no, we'd rather have the strings attached and have to beg to be able to use it for this, that, and another instead of opting to use all of our allotment as if it were lost revenue. I'm not saying that it's lost revenue, it's just they allowed you to claim that. So we opted not to do that just a minute ago, and so I'm going to have to get some guidance now from, you know, I think that had we adopted that, I don't think there's any question this would be legitimate, whether the court would agree to it or not, that's a different story, but
I understand.
it would be a no-brainer, we could opt to grant that, so, I'm gonna ask that we delay any action on that until I can get some guidance from KIPTA and, U.S. Treasury on it, so.
Understand. Thank you.
All righty?
All right.
All right.
Judge, maybe I don't have a brain, but these ARPA funds, that is what is hurting people right now
Yeah,
across this country.
okay.
You know, that's why, that's one of the reasons why all of our prices are so sky high right now.
So if we don't.
And so the Democrats have dumped this in our lap. Oh, okay. All right.
What I'd like to say is,
Yeah, well,
I understand that we want to change the rules and how to make it easier for everybody. And I think that's great, because they don't have enough manpower in Washington to oversee this anyway.
yeah.
But when they start saying, you're saying this is, you're claiming this is lost revenue, you know, we didn't lose revenue. That's
No,
what
we're not
saying.
claiming, we are,
we'd
they
be-
allow us to use it as if it were lost revenue and under those guidelines of using
But that's
lost
not what it
revenue,
says.
which is broader use than, some of the other
How much
uses.
cheating on your taxes?
So, you know,
That's not what
frankly,
it says.
frankly, I mean, you know, we're, you know.
Remember, this was split 50-50 in the Senate and in the House.
Yeah.
Even had one Democrat on the
Look.
Senate that voted against ARPA.
Let me just say this without, you know, assume that, and I believe, and I would tend to agree with you, Star Beaverson, that the national debt is unsustainable. This simply added to the national debt. But I have a question. If we took the $3.758 million from Spencer County and sent it back to the U.S. Treasury, can you tell me how that would change anything with regard to our national debt or the needs of our county?
That kind of thinking across this country is exactly.
Well, I'll give you the answer. We can write a check and send it right back to the U.S. Treasury, and it's not going to make one bit of difference. Okay? So, we're going to move on to Kentucky Transportation Rural Secondary Flex Funds. Let's see what we can get into there. We have been allotted $128,981 for flex funds, and I need your all's approval.
Motion to approve.
To approve the signing of that contract, and I believe there will also be some carryover in addition to that. I'll get that for you. But we got a motion, Squire Beaverson, and Squire Travis seconded, if I'm correct. A motion second, any discussion? All those in favor say aye. Aye. Anyone opposed? Hearing none, motion passes. We've got some repairs that need to be made over at the courthouse. One is a urinal in the first floor men's room. The other one is a urinal in the second floor courthouse men's room. I have those split because of the AOC reimbursement. They reimburse 100% for what's on the second floor and only 52%, I believe, of what's on the first floor. So I'll need a motion to approve the replacement of those two urinals. That can be made in one motion.
So approved.
We've got a motion.
Same old difference.
And who seconded that?
I will.
All right.
Discussion.
Any discussion?
Yes,
All right.
we've got one quote. And we have dealt with this issue over and over again about having one quote for doing maintenance work or repair work. And again, here we are with one. This is a plumbing issue. I'm sure there's other plumbers out there other than RBK that can do this. I just would like for the court to get back to where we at least two quotes on everything from now on.
Okay, I assume that's going to be a no vote. So we've got a
No, it's
motion.
not. You don't assume.
You would assume does to you?
Yeah. I would, if we're gonna go to that, recommendation, then I would ask that, if we only have one quote, don't put it on the docket. Don't put it on the agenda.
I don't think we,
We have always been under that.
I understand.
Okay, we're not changing.
No, I'm not. I'm
all right, we're gonna. Any other comments? Call the roll, please.
Squire Travis,
Yes.
Squire Jerry Moody,
Yes.
Squire Brewer,
Yes.
Squire Mike Moody,
Yes.
Squire Dickinson,
Yes.
Judge Riley.
Yes, I'm shocked. Thank you.
It's not about shocking. I mean,
Well, we're gonna move on. Next item is corner van stripe.
problem about it?
I don't wanna talk about
Well,
it. Okay, next issue is corner van. We got two quotes on that. One is for $821.44, the other one for $595. The coroner has gotten these quotes, and she recommended that we go with Kyle Sims, which happens to be the lower quote. And that information is in your packets. I'll entertain a motion.
Make a motion to accept the $595 bid.
All right.
Second that.
And it's, any discussion? It's only two quotes, but all those in favor say aye. Aye.
Aye.
Anyone opposed? Motion passes. We'll get that done. Next up is our,
Judge, hold on.
yeah, go ahead.
That's a brand new van that we bought, and that van needs to be parked inside.
I agree.
So can you communicate with them and if they need to clean out the garage, get some of the garbage?
They need to
out?
do something because that needs to be inside.
And she might need a key to it in order to get in at 3 o'clock in the morning or something.
Yeah.
like that. And I we gotta operate the overhead door.
Okay. Anything else? We've got the monthly financial statement, I believe is in your packets. And next up is invoices, bills, and transfers.
Make a motion that we pay the bills, do the transfers, need to add a transfer from the reserves for $71,150.
We can add a transfer from reserve for transfers 01-1900-999, which is reserve for transfers to the lighting account number, and I'll send an email over to you tomorrow with those account numbers. And I'll make the motion
That includes the additional transfer.
Second.
And we've got a second. Any comments, questions, or concerns? All those in favor say aye.
Aye.
Any opposed? Hearing none, motion passes. Next up, is there anything else to come before the court? If not, I believe Squire Beaverson has a motion to make.
Motion to adjourn.
We've got a motion to adjourn, and Squire Jerry Moody has seconded that. All those in favor? Aye. We are adjourned. Thank you all very much.
Yeah, I'll get it from the Jack.
Thanks for coming. Sorry. How you doing? I'm doing good. I've been over there.
Right, especially, hopefully long before the tournament.
Together, right?
Well, I couldn't get out of my meeting, because I had a meeting with my people.